Mr. Rayner, I'm a little curious about your statistical argument. So let's say that that your office files a motion for emergency relief, and you want to try to convince us that there's a probability that we're going to grant certiorari. If you, in making that argument, you say, look, we're very selective in the Solicitor General's office about when we're going to petition for certiorari. We get lots of requests from the litigating divisions to file cert petitions, and we go along with that in a tiny minority of the cases. And we have quite a good record of success when we do petition for cert. Is that something we should consider in that context?
Justice Alito, I don't think there's any bar to the court considering it. And just, if I may.
Seriously?
I certainly don't think there's a bar. This is an equitable analysis. But I think the context here is different in that Congress—
Yeah, I think you're going to have to tell me why it's different.
The reason is that Congress has set up a scheme where the agency can seek 10J relief to protect its own adjudicative authority. And as Justice Daxton mentioned, the history here is that initially there was pretty widespread judicial intrusion into labor disputes. And in 1932, Congress cut that off and said we're not going to allow district courts to intervene. And in 1935, it centralized adjudication of disputes in the board. In 1947, it decided it had to walk back its restriction a little bit, and so it allowed Section 10J relief. But it didn't allow Section 10J relief for district courts to engage in a wide-ranging and intrusive involvement in labor disputes. It allowed courts to come in basically as ancillary to the agency proceedings and protect the integrity of those proceedings. And in that context, I do think it is relevant that the board is selective about the petitions that it files.